Hello, everyone. My name is Giulia and I'm a PhD candidate in comparative constitutional law at the University of Torino. And I'm also part of the editorial staff of Diritti Comparati. I'm excited to introduce today's guest, Professor David Bilchitz, who kindly agreed to give an interview for our blog. Professor Bilchitz is a professor of fundamental rights and constitutional law in the Faculty of Law at the University of Johannesburg and director of the South African Institute for Advanced Constitutional, Public, Human Rights and International Law. He's also a professor of law at the University of Reading in the UK. He was appointed in October 2023 as an acting justice of the Constitutional Court of South Africa for the first term of 2024. Professor Bilchitz was also the Secretary General of the International Association of Constitutional Law from 2013 to 2020 and is now a VP of the association. He was the lead organizer of the World Congress of Constitutional Law, which took place in December 2022 in Johannesburg at the University of Johannesburg. His research addresses a range of topics in the field of constitutional law and fundamental rights, including, amongst others, proportionality, socioeconomic rights and fundamental rights, the separation of powers, the rights of non-human animals, the tension between religion and equality, and LGBT plus rights. Professor Bilchitz, thank you very much for participating in this interview. Let's break the ice, I suggest, with the first question.
Thank you very much, Giulia, for the invitation, and greetings to all those who are watching this interview.
Thank you. So I suggest that we move on to the first question. So we're approaching the 30th anniversary of the South African Constitution. How do you assess its trajectory, especially in light of your experience now as an acting justice of the South African Constitutional Court?
Thank you, Giulia. And I think to answer your question, we have to understand that the South African Constitution, there was a massive task that the South African Constitution had to perform because it was coming from really centuries of injustice in South Africa, and a legal system which had entrenched inequality and discrimination on grounds of race. And the Constitution had to help us and provide the framework essentially to reconstruct the society and to create a common society founded on the three principal values of the Constitution: dignity, equality, and freedom. And so we often see the Constitution as a bridge between an unjust past, which was rooted in inequality and hegemony and power, to a future which was equal, participatory, full of freedom and social justice. And of course, moving from that historical legacy to a different future was not going to be a simple task. It was something that was going to take time, and has indeed taken time, and there would be various obstacles along the way. And one of the interesting features, as you asked me about the Constitutional Court, which I was very honored to serve on last year, is that there was actually the creation of a new court, because the court system itself couldn't be trusted with that huge power, essentially to strike down legislation or the conduct of the president, where that court system had itself been part of the previous unjust order. And so at the top of the South African judiciary, there was a creation of a new court that was filled with people who were instilled with the ethos of the new order and who would represent, in a way, broadly, the diverse makeup of South African society. And so you asked me a little bit about what has happened. How do we assess the trajectory? Well, it's a big question, but I can mention some successes and some real challenges, right? Some successes, well, South Africa, on the one hand, we could have had a civil war, and the Constitution essentially was a type of a peace agreement that brought people together and averted that civil war. And South Africa today is a broadly peaceful society. And so that in itself is a huge success, where we see the shadows of injustice often, preventing the movement forward into a peaceful, stable society. South Africa has also built a vibrant democracy, and that actually had its next instantiation last year, where there had been the rule of the majority party, the African National Congress, the Liberation Party, for almost 30 years. And that party lost its majority for the first time last year, and there was the introduction of coalition government. So that shows South Africa, in a way, that trajectory. There was a peaceful transition to a coalition government, and that it's built quite a stable, strong democracy, where we can certainly say civil and political rights are very strongly protected. And there's anyone who comes to South Africa will know there's a strong sense of free speech. At the same time, there have been many challenges. One of the big problems that has arisen is an issue of corruption, that many parts of the state have been corrupted, which have led to real problems of delivery of services for many people in the country. And that corruption was recognized to stem from some of the highest levels of state. And the Constitutional Court in the last 10 years has had to, in a way, deal with a lot of rule of law issues, simply to prevent the corruption, the further corruption of the state. There's also been problems of capacity in government, inefficiency, and that has affected the ability to fully deliver services. And then the big major issue, which is the problem of changing the society from a socio-economic point of view. And South Africa had deliberately entrenched a system of inequality, which led essentially white people to be privileged from a socioeconomic point of view, and black people, to suffer from that perspective, and to have, in many ways, be seriously disadvantaged socioeconomically, and trying to correct that, to redistribute wealth in a way to ensure that everyone at least has a minimum decent level of access to socioeconomic rights. That has proved very, very difficult in South Africa, and we're still struggling with that transition in many ways. And there have been some successes along the way. There has been government spending. There have been development of housing, but at the same time, and many black people have moved into the middle class and achieved significant wealth in some cases. But there still remains a significant number of people who are living in very serious poverty, without jobs, and with poor education on offer. And that's something that really the Constitution alone cannot sort of address, but it provides a framework which perhaps, if that framework were more strongly implemented, would provide a roadmap to address some of these issues. And some of my work has criticized the lawyers, the judges, for not being strong enough in implementing socioeconomic rights and in requiring the other parts of the state to take strong action in that regard.
Thank you. That's surely very interesting. I'm sure that you had the chance to work on that also as an acting justice in your as part of your personal experience. And with regards to your to another experience of yours, I would like to move on to the next questions. And you were the Secretary General of the International Association of Constitutional Law, as we have said, and are now a VP. You had the honor and responsibility, I would say, of organizing the World Congress of Constitutional Law in Johannesburg in 2022. Could you tell us more about this experience, and has this kind of involvement had an impact on your work or the way you engage with your colleagues?
Absolutely, no doubt, Giulia. Being Secretary General and then Vice President of the International Association has been a tremendous privilege, a tremendous honor to serve this august association. But apart from that, I think most importantly, it's enabled me to have formal and informal conversations with people across the world, to get to know people, for instance, in Italy, as we discussed, and to recently be at a conference in Rome, where often these kinds of engagements often happen relatively informally. And one goes to various congresses, round tables of the association, And that offers opportunities to engage with different systems, to see the way legal doctrines develop in different places, which of course expands one's horizons, expands one's understanding, and also gives one a really clear view of what the cutting edge discussions are in the discipline. So it has been quite transformative for me in many ways. And I think those networks, I really encourage people to do that and to sort of build those international connections. And that often leads to collaborations and affects one's research, and just it has multiple benefits. So I'm a great fan of these kinds of interactions. You mentioned the World Congress of Constitutional Law. Well, that was a wonderful opportunity. I saw it had never been in South Africa, to bring the world of constitutional law to South Africa, which has also made an important contribution to constitutional law, and to sort of bring those global conversations in local conversations. And so we were very privileged to have, just after COVID, we didn't know if we were going to be able to go ahead, but we had a fantastic array of people come from across the world, a really large Congress, and really a sort of opportunity. Also, what we sought to do is to live our constitutional principles. And so what we sought to do is, in a sense, not just organize a conference, but organize a conference which paved the way for how we wanted to see the world. So we took some people regard it as rather strong step of having all the food being vegan, essentially moving to plant-based diet, recycling, ensuring that local people who could sell their crafts could come into the conference, and so in some senses allow them to earn livelihoods. And so, and that, in a sense, in a way, we felt can show how we need to think in everything we do of how we live those constitutional principles. And I'm very happy to say that subsequent to that, the ISCL invited me to head the Sustainability Commission of the association, and we're setting up a whole range of guidelines for future events, which can instantiate principles of human rights, protection for animals and the environment in the very way in which we organize congresses and conferences.
Thank you. That's very interesting for sure. And with regards to human rights, I would like to start discussing about your work a little bit more. So an important part of your research addresses human rights and business, which is a classic theme that continuously demands for further exploration. And the topic transcends multiple dimensions. I'm thinking about the public-private divide, or multiple dimensions such as the national, international, supranational, transnational one, just to name a few. This challenges us not only to find new answers to old and emerging questions and issues, but it also requires us to ask new questions. So I would like to know what key questions have been driving your research.
Thank you very much, Giulia. You know, I started off working for my PhD and my first book on poverty and fundamental rights, and how to adopt a viable model towards socioeconomic rights. And one of the things that I realized as I was working on that was that the picture was not complete by focusing only on state obligations. One had to also think about what was the impact of the private sector in both exacerbating poverty and potentially contributing to alleviating poverty. And so it sort of naturally led into my next research project, which became very strongly on this issue of business and human rights, and the role and responsibility of businesses, and we can extension say other private actors in relation to fundamental rights. And in this area, you asked me what my areas of focus are. I started very practically looking at the South African Constitution, which extends application of the Constitution not just to the state, but to other actors as well. And that has been developed over time. I also looked, as you say, this kind of topic links because business and the way things are done today are global. So I engaged with the main document that was emerging at the time, the United Nations Guiding Principles on Business and Human Rights, and myself and Professor Surya Deva co-authored a book where we considered the first critique of those principles, and then the new initiative to kind of create a treaty on business and human rights, which I feel is strongly needed to address the major gap in international law. And so I've played a role in that, and some of my scholarship. I also co-edited a collection with Professor Deva on looking at what should go into such a treaty. But my recent monograph has actually focused on what I saw is a gap in the scholarship, which concerns how to determine the content of the obligations that business should have in relation to fundamental rights. And I found that there was a lot of discussion of obligations in relation to the state. There were a lot of discussions of quite practical issues in the business and human rights sphere, but very little analysis of what the obligations of business should be. And so my book sought to firstly analyze existing models, even where there's a denial that there's some, by some courts, that they engage with this question. They often do. And then I sought to take what I learned from those particular models to systematize it, develop it in a particular way to suggest how do we address both the negative and positive obligations that business may have flowing from fundamental rights. Negative obligations, for instance, relating to technology companies or ordinary workplaces, which impact on our privacy in a day-to-day life. Positive obligations relating, for instance, pharmaceutical companies that manufacture pharmaceuticals. Do they have obligations to provide access to medicines or to price their drugs in ways that are affordable? And so these are big and hard questions. And I sought to provide a model, hopefully an opening conversation, which encourages more scholarship in this area. And then I kind of concluded by thinking a little bit about some of the more practical questions of how do we, what structures make these decisions about obligations, looking on the domestic level of how we need to transform company law to take account of fundamental rights, and then what kind of structures at the international level must exist. So that's my more recent monograph, which I hope still will get more attention and encourage more discussion of what I think is a really important question, both for the future.
Yeah, let's hope so. Thank you. You've also been focusing extensively on animal rights, arguing that the South African Bill of Rights could and should be applied to non-human animals too. It is a fascinating and surely thought-provoking topic, which challenges our preconceptions regarding legal subjecthood. Could you guide us through your line of reasoning, please?
Absolutely, Giulia. You know, it's a kind of a flip side of the other question, because the question about obligations, right? It does the obligations, who has the obligations in relation to rights? And here I'm asking who is entitled to the protections that rights offer, to those entitlements, and who is the subject of rights? You know, and in South Africa, we were subject to a really arbitrary system, which sought to say that white people had certain rights and black people didn't, right? Like the right to vote in the political community. And the question one has to ask is, why should skin color matter at all in relation to having certain basic rights? And so it made certain arbitrary distinctions. We had also certain, you know, historically women were denied from access to certain basic rights. And they were under the marital power of their husband until the 1980s. They couldn't be lawyers in South Africa, as in many other countries. And one has to ask, why does one's sex or gender matter at all in that regard? And if we take that logic, we also have to ask ourselves, why does species matter that much when it comes to to having rights? And humans are very much focused. It seems to be a little bit of a blind spot. We tend to think, oh, well, we're the ones who's special. We rule over the rest of the world in some sense, and we can do whatever we like into the rest of the world. But why are we entitled to that? Why are only humans entitled to rights? And if we start asking that question, we find it's quite difficult to give a good answer to that question. We might say, oh, we're very intelligent and we're the most intelligent of animals, etc. But we find that we accord rights to human individuals, for instance, who lack high-level cognitive capacities. For instance, very young children, people who would never develop it for some kind of disability that they may have. And so we don't deny rights from those individuals. We recognize them as rights bearers. So then there's no good reason why we shouldn't also recognize creatures who have different ways of life and modes of life from also having entitlements and claims on us. And so essentially, I believe that the foundation for that is really having a consciousness, and having a conscious awareness of the world, being a sentient creature, being able to feel. There's something like to feel inside. And if we are a subject of that kind, then we can be harmed as individuals. And therefore, we need certain protections and we have certain entitlements. and we can make certain claims. And so once we look at that philosophical understanding, which has grown over the years and is quite strong in the philosophical community, we need to consider its impact on law. And I considered, well, once South African constitution stands against arbitrariness, how can it arbitrarily focus on only humans? And I sought to show in one of my articles and some of other work why the South African constitution can actually be interpreted to extend rights also to non-human animals as well. And then to grapple with some of the problems that raises, because most human societies today, including South Africa, are very implicated in exploitation of animals. And it's very difficult to immediately move to a world where that exploitation ceases. As much as I would like to move to such a world immediately, I realized that a court could not immediately force certain changes on the society. And so we need to think, how can constitutional doctrine allow us both to recognize the ideal of recognizing full animal rights, whilst also still managing that transition of human society? And I think it's similar to some other cases, for instance, like socioeconomic rights. And I've suggested where we can perhaps look at doctrines like progressive realization and other ideas to actually ultimately pave the way for the fuller recognition of animal rights too.
Thank you. So ultimately, do you think that there's a link that ties all these topics, so socioeconomic rights, animal rights, and so on and so forth? And my question is, do you think that we are perhaps moving towards a new way to look at constitutionalism, constitutional matters, and so on and so forth?
Yes, I think there is, Giulia. And as I said, I think they linked. And I think that the first element that linked is, I think we need to think very hard-headedly about rights, thinking very seriously about those kind of questions. Often people summarize it as who must do what for whom. Who is the obligation bearer, must do what? What's the content of those rights? For whom is the bearer of those rights? And we need to think very hard-headedly about that question, and also not be stuck in the dogmas of the past, which don't necessarily represent what rights really are about, right? And I think that moves us to maybe a more substantive link in some ways between these different elements. And the first is, I think, considering the vulnerability of all those of us who are in a way sentient, are vulnerable to the exercise of power by others. Some are more vulnerable than others, but we all have a degree of vulnerability to others. And the second issue is power and the potential for the exercise of power by various actors and how that impacts, that's the other side of the coin, on that vulnerability. And I like to think that relationship, power and vulnerability, actually puts us in the sort of very strong notion, which is actually, we can learn from African philosophy called Ubuntu, which says that a person is a person through other people. We are centrally connected through ourselves, and we only come to be full persons through our connections with others. There are similar ideas in feminist thought about rights as relationships, for instance, as Jennifer Nadelsky talks about. And it seems to me that actually when we start thinking about these things, it's really about the interconnectedness that we have, and thinking about, as a result, our obligations to each other through that interconnectedness. And, you know, one of the problems is that we see increasingly people to say, well, I'm an island unto myself. I don't have obligations for others. And I think that rights culture is the counter to that. It's the opposite of that. It says, no, you have a right to your own personal autonomy, but you're integrally intertwined with others. And so you cannot say, I am not my brother or sister's keeper. I am indeed deeply interconnected with them and must therefore be concerned for their vulnerability. And without being concerned in that way, I am not a full person.
Thank you. That's absolutely fascinating. But on the other hand, I would say we're also navigating hard times. And because on the one hand, we have been witnessing the emergence of new rights reflecting the increasing complexity of our reality, from the pluralism of personal and collective identities to issues related to technology, nature, the very idea of legal subjecthood, as we have been discussing. And this represents a leap forward for the doctrine. But on the other hand, both the global north and south have been facing dramatic setbacks in constitutional guarantees of the rule of law and protection of fundamental rights, which were once taken for granted, with democratic erosion and authoritarianism becoming widespread. So my question is, how do you take account of this tension that exists in your research? How do you, let's say, keep it real without yielding to either utopianism nor absolute pessimism vis-a-vis the current state of constitutional matters?
Yeah, I think we need to recognize, and it's a great question, that we're in a dark time at the moment, and it feels very difficult to stand up for many of these values. But it seems to me that rights, in a way, provide us with part of that answer when we think about their very nature. You see, my way of thinking about rights is rights are essentially, they're moral ideals in a certain way, but they're so important, right? They have such an importance and fundamentality that they, in a way, put a pressure on us to institutionalize them in law. We have to find a way to institutionalize them in law. And then there's these two dimensions that, in a way, are in tension. There's this ideal which we're constantly striving towards, and then we're trying to bring that ideal into reality through the concretization in law itself. And in constitutional doctrine, many of our systems, like South Africa, have a two-stage approach to rights, the interpretation. The first question is, we ask, is the right implicated? Is it violated? Is it infringed in some way? And that requires us to identify what the right really protects, what the ideal protection is, and whether the issue before a court, for instance, falls within that ideal protection. But the second stage involves asking, well, assuming it is infringed, can we justify the limitation? And that requires us to consider a range of conflicting normative issues, sometimes a range of conflicting practical issues that the government is at stake, and finding some kind of balance or proportionality between those kinds of issues. And, and so we face some very hard, I'll give you an example of a case in South Africa in the early days of the Constitutional Court, the Subramani case, where a very, very sick individual needed access to kidney dialysis because his kidneys were stopping to function. And he couldn't afford to pay for this in the private sector by himself. He needed it to be provided by the state. And he claimed that he had the right to life and the right to access to healthcare services, and the state must provide it for him. And of course, here you had, on the one hand, a very severe, very important demand against a very difficult issue that South Africa wasn't a very wealthy country, has many competing issues, and kidney dialysis is quite an expensive treatment. And the Constitutional Court in general said, well, because of the scarce resources, because of the lack of resources, Mr. Subramani did not have a right to kidney dialysis. He did not even form part of the right to have access to healthcare services. And in my view, that's the wrong approach to adopt. The right approach would have said, Mr. Subramani does have a right to have access to healthcare services, and that includes kidney dialysis. It may not be possible now to provide him with those services, given the current state of resources. But the state has a continuing obligation to unlock the obstacles to increase the resources available so that eventually everyone will have access to dialysis when they are able to do so. And so that shows you, it illustrates what I'm saying. We need to not interpret rights in a way that does away with them, but keep our eye on the ideal and try and encourage doctrine to push us more towards that ideal. And so I want to come to what you asked at the end. Well, what do we do about the current state of the world? It feels very pessimistic. I mean, the world's never been in a good state in terms of rights perspective. And I suppose you can always look at the negative side. We have made a lot of progress as well in the way in which human rights are recognized in the world. And I think pessimism can really be self-defeating. And what we need to do is we need to kind of recognize that rights are in some senses the antidote to some of the negative elements that we see at the moment in the world. We need to redouble our efforts to stand up for those things we believe in. and to ensure that we reject a notion that the world is constructed on might makes right, that the world is constructed actually on claims that individuals have from one another, and respect, care, and compassion, and fairness. And we need to stand up for these ideals even more strongly in the current environments. And we need to use our skills as, in a way, legal scientists around constitutions to think about how can constitutions in some ways resist and stand up to some of the strong populist forces, strong negative forces that are coming into our political communities at the moment.
Thank you. Thank you very much for your very interesting answers. So I would like to make a couple of final questions. The first one would be regarding dialogue between colleagues from different legal systems. How do you see it? What's your take on dialogue between colleagues from different legal systems, also considering that the South African constitution elevates it to a tool for constitutional elevates the use of comparative law as a tool for constitutional interpretation?
Thank you, Giulia, because the South African constitution, of course, as I mentioned to you, it was a very unique task for the first court. They had a tabula rasa. They didn't have any prior real constitutional law that they could utilize. So they needed to, the constitution drafters also thought about this. Well, where they're going to look they need to look somewhere else. And so the South African constitution is expressly globalist. It looks to international law, and it looks also to comparative law, and to really engage with what others have done, and then consider whether they are appropriate for us. And so I think that's the first thing. We can think of dialogue in two ways. I would suggest to you. One way is as an instrumental way of dialogue. We can learn from each other. We can look at what people have done. We can consider alternative ways of doing things, and then we can utilize them to our own ends, and so improve. We can see experiments that were done elsewhere, for instance, and then utilize them to avoid the mistakes that were made and to improve our current societies as well. But I would suggest to you there's a sort of deeper idea of dialogue as well. And I alluded to this earlier, of dialogue where we are ourselves involved in that conversation, where we see ourselves as compatriots involved in a common project towards achieving justice, and where we ourselves are changed by that very dialogue and are open to being changed. And that's a kind of deeper sense of dialogue than simply looking at different systems and trying to understand them, but actually sort of engaging with one another in a real sort of open way, generous way, to try and transform ourselves through that interaction, through that relationality that I talked about. And I think one thing we need to be aware of, and I think this is a concern of mine, of course, we mustn't be naive. There are also power relations between global North and global South. I know myself, I've often seen there's been global North scholars who will write about South Africa and not actually even engage with what South African scholars are saying. And I think we need to ensure that those forms of inequality in the scholarship community and the academic community, we try and address those, and we try and address the sense often of the global South as feeling a degree of inferiority and that we must only learn from the North. Actually, we have unique experiences, unique opportunities to contribute and to shift the global conversation of the North. And then that notion of superiority of the North also needs to be challenged, and scholars also looking to the South for both, and so there's this sort of interaction in a more equal way. And I hope that we will, it's been improving, of course, over time, and I hope we will see that build and develop even more through fora like international associations, through international judicial dialogues, and various other methodologies and ways of being.
Thank you. Let's hope so. Let's hope for the best. And finally, what do you think will be the next hot topics in comparative constitutional law? And I'm asking this to discuss both your current and future projects, and which we are very interested to hear about, and your opinion on what young scholars should focus on. So what questions should we be asking in order for the doctrine to remain relevant and impactful, most of all, in the world?
Thank you, Giulia. I mean, I certainly don't want to. I think people often, one of the great things about our area is that people will come up with their own questions and will see problems that that others don't see. So I would hope young scholars would have a different view on the world and would challenge those of me who's reaching very soon middle-aged scholar, to also think about things differently. I also want to sort of say, I think sometimes hot topics sometimes become very popular, but they're not the most important ones. So people should also feel able to sort of burrow away on things that they regard as very important, and in some senses enhance the scholarship through what they see are the gaps that exist. I will say to you, I think there's some things that we're seeing in our world at the moment. We know there's been a rise of scholarship on populism and democracy, and I think those are going to be big questions, obviously, for the future about how constitutions can kind of rein in some of these negative tendencies that are occurring in democracies. I think we're also seeing a growth of terrible xenophobia in many countries around the world, and saying if you're not part of us, no matter how desperate you are, how much in need you are, we reject you, we treat you very badly. And I think we're going to need to see challenges to that. In terms of my own work and more personally, I'm currently working on a paper relating to something we spoke about earlier, which I see as a big gap, is how do constitutions address those who lack a voice of their own within the political community, and particularly I'm focusing on non-human animals. How can we, in some senses, create structures for creatures who won't speak a human language, but nevertheless have lives of their own? And looking at some particularities of the experience of some of those structures at the moment, looking in South Africa and seeing some of the flaws and how we can improve them in many ways. I'm also very interested to reflect a bit on my experience of having been an academic who landed up having a peek behind the judicial curtain. And so to think a bit about some of those questions that arose about how judges deliberate and some of the things that I worry about, like how sometimes I saw form and procedure getting in the way of substantive justice and how we can do better in that regard. And lastly, on, I think, more some of the substantive issues, I'd like to see a rebalancing of some of the fundamental rights discourse. Obviously, I feel passionately about the areas in which I go into, but I do think that the issue of private actors, businesses, and their role, it's becoming increasingly prominent. We're seeing business people in very senior areas of governance in some parts of the world, and that's very concerning, and actually businesses actually turning around their policies. And we need to think very carefully, I think, about the role of private actors more strongly. That needs to be a bigger focus. And then broadly, that issue, which still remains with us so strongly and is perhaps the heart of so many problems in our world. So many people are struggling so badly from a socioeconomic point of view across the world, and some people are doing so well. And how can we find a way to, through constitutions, through international law, to share better, so that we all at least have a decent minimum of existence for all of us in life, and that we can do away with that high level of desperation. So I would like to see more emphasis on those kinds of questions. But those are just some ideas of what are, of course, lots of issues in a very changing world of AI and climate change and so many other issues which people can, of course, raise.
Thank you very much, Professor. I'm sure these inputs will give us a lot to think about. And I think it's a wrap. So thank you, Professor, for being with us. You've been very generous to us. So thank you again, and many wishes for your future projects. Thank you for being here today.
Thank you, Giulia, for the wonderful interview, and all the best to you and others in Diritti Comparati with your blog and all the projects that you and your listeners are involved with.
Thank you.